Hello. Today our topic is going to be consumer arbitration, which I'm going to argue is a bad thing. Let me explain what I mean by arbitration. Normally, if people have a dispute over a contract or a transaction, we presume they'll go to court where their case will be judged by a judge or a jury. Or perhaps a judge will rule in matters of law and a jury will rule in matters of fact. But it will be in a public forum, one that's paid by the taxpayers and one where everyone has reasonably equal access, and where you have an opportunity to be heard in a fair and impartial manner. Increasingly, however, people who buy things, everything from cell phones to stocks and a host of things in between, are being forced or required to sign contracts that provide for what's known as consumer arbitration. This means that you waive your right to have a judge, waive your right to have a jury to decide the issues between you, and instead the question will be decided by a private party who in most cases is retained by your creditor or the salesperson. Now, in America, the law favors arbitration, and you have to understand a little bit of history as to why it favors arbitration. Back in what are now the last century, and now a very long time ago, in the opening part of what was the 20th century, the courts were highly prejudiced against working people and labor unions. And in order to give labor unions a chance to make deals and establish a law of the workplace, the Federal Arbitration Act was passed. And essentially what it told the federal courts was, stay away from these private arbitration agreements and let these people work out their own destinies and their own lives. Now, arbitration in a commercial setting or arbitration in a labor setting has an opportunity to work. And the reason for that is repeat transactions. Any arbitrator who's unfair to management consistently will be deleted from panels by management. And any arbitrator who's unfair to labor consistently will be deleted from panels. The fact of these repeat transactions and that people have to choose you produces a situation where the decision maker gravitates towards the middle, gravitates towards fairness. Now, the other intent that existed in the labor law or even the commercial law environment that doesn't exist in the consumer law environment was the intent to create a sphere separate from the operation of law, and to really create in the 20th century and again in the 21st century something that resembles the guild operations of the Middle Ages or the early modern period. What they were attempting to do was to separate out groups that were organic and worked together and had their own rules, own traditions, and own habits, separate those out from strangers who would try to impose, other groups' laws on them. And this would permit groups like carpenters or plumbers or fishermen or whatever it was to work out their own problems by the ethics of their own community and the values and whatever it had, as opposed to the general common law, which might not be that sensitive to them. Unfortunately, none of the things that make arbitration reasonable and make it work apply in a consumer transaction. If you buy a cell phone, how many times, and all the cell phone sellers have arbitration agreements, how are you going to make a choice? And it's also true that arbitration in the consumer context is not what it is in the labor context. Arbitration generally costs more. You can find yourself paying not only a fee to enter into arbitration, you can find yourself renting a room where the arbitration is conducted, paying for all kinds of things that you wouldn't pay for if this were done on the public dime, and ultimately you have a judge who's been bought and paid for by the very person you want to dispute with, and a person who expects never to see you again, but who knows if he disagrees with the person who brought them there, that he's not likely to come back or to get paid or to get fed again or to have a good career. Sometimes the rates are so bad that there's that one company that's known for only having something like one consumer win out of every so many hundreds. It's devastating. It's a waste of time and a waste of money. Now, it is so bad that the American U.S. Comptroller of the Currency has made it an unfair banking practice for a bank to include a consumer arbitration agreement within, like credit card agreements for banks or other things that banks do. And if they want to offer you such an agreement, they have to offer you something in exchange for it. They have to give you something of value or let you opt into something else. But most people don't know that, and most people who engage in consumer transactions, when they find themselves being forced into this situation, really have very little opportunity for redress. It's time to change our national arbitration laws and free consumers from the burden of these things, which have no economic sense towards them and don't result in common sense or justice. Thank you.